Can an employer file for immigration status for one of their employees who's here without papers or out of status or undocumented? Tune in today, we're going to talk about that issue. Hi, I'm attorney Jeff Peek with the Peek & Tolan Law Firm. And one question I get often from people, sometimes employers, sometimes the employee, is, hey, can my employer sponsor me on a visa for work? And of course, there's all sorts of work visas that an employer can use. The question is, what if you're currently here in the United States already and you're unlawfully here or illegally here or without status? That becomes very complicated. One of the hardest things to do in immigration law is to go from no status or out of status or undocumented, however you want to call it, and then go from that status into a legal status. In fact, sometimes for some people, it's not even possible. But there are a few ways that somebody might be eligible. I'm going to talk about this real briefly. So one way is, it's an old law called 245I. Now you don't see this very often because we're so far away from the last time they renewed it. The last time it was available was in 2001. You had to have had an application filed on your behalf before April 30, 2001, which is almost 20 years ago. You had to be physically here before December 17, 2000. And so you just don't meet a lot of people who fit those requirements. But if you do, if you happen to be one of those people, or you are a beneficiary under somebody who had that, sometimes you see a parent who had a petition filed by a sibling, for example, and the child was a part of that, was a derivative beneficiary on that. Sometimes you can find that. That application serves as a waiver or a pardon, or in Spanish we call it perdón, or you can pay $1,000 and it waives all your unlawful presence. The second opportunity is if you are willing to go back to your country and try to apply for a waiver. The problem with this is there is a waiver available to waive you for a non-immigrant visa, such as any work visa. If you go back to your country, the problem is you're not guaranteed to win. So there's a little bit of risk involved there that you're going to travel outside. For many people who've lived here for years and years and years, that's not worth the risk. Obviously, they've got houses here, they've got family, they've got kids in school, and it's not worth the risk for them to go back not knowing if they're going to get approved for that waiver. That's another way. Third way is if you are eligible for one of the remedies that are out there in immigration law, like U visa, deferred action, some of the other ones that VAWA, that allow you to, even if you enter the country illegally, to get a work permit for those programs. Now, each one of those programs has their own requirements. I'm not going to go over them now, but if you were a young person who came to this country and you've heard about DACA, you may, deferred action, you may want to talk to a lawyer about that. If you've been a victim of domestic violence and your spouse is a permanent resident or U.S. citizen, you want to talk to a lawyer about that. And if you've ever been a victim of a violent crime, even if it was somebody you didn't even know, doesn't matter if you're undocumented or the other person's undocumented. If you were a victim of violent crime and cooperated with the police and cooperated with the prosecutors in the arrest of that person, you may also be eligible for that. Those are different pathways to, without having to leave the country, where you don't have to get a waiver. And then lastly, there are some people who came in with a visa, but overstayed, and they didn't go back when they were supposed to, and they've been here a long period of time. A lot of times the employer is not going to be able to file for them in those situations again, unless you qualify for one of the things I already mentioned. But you may sometimes have somebody in a situation where they overstayed but then have married a U.S. citizen down the road, or have a 21-year-old U.S. citizen child who can file for them. And that period of time that they're here gets waived if they have those circumstances. Legal entry, U.S. citizen spouse, or U.S. citizen child is 21 years old. So as you can see, there's just not a lot of options there for people who are undocumented to go from undocumented status to visa status here legally inside the U.S. Unless they have one of those exceptions. And so that's the hard part. Even if you have an employer willing to cooperate, if you have a qualified candidate and the employee, it's not as simple as you would think. So hopefully that helps you in making decisions if you think you might be eligible. It's always worth that. Talk to a lawyer, you never know. We have to evaluate all sorts of things about your background and your immigration history to make sure we evaluate all the possibilities and scenarios. But that's a pretty big good snapshot of the way it looks when you are undocumented and you have an employer who wants to file for you. All right, that's all we have today. If you need any questions or you want to follow up on what we talked about here today, give us a call, shoot us an email. You can look for us at peekandtolan.com or abogadoswidows.com. We'd love to talk to you. Have a great week.